With the coming of civil wars and armed conflicts, many eyes in the imprisoned Middle East turned hopefully, or desperately, toward the freedom of Australia. Indonesia became the great embarkation point, but not everybody could get to Indonesia directly, and so a tortuous, roundabout refugee trail sprang up. Afghanistan to Pakistan, across the desert to Malaysia, then by train, or auto, or foot, across the subcontinent of India to Indonesia. Here they board fishing vessels bound for Australia, where they are intercepted and taken to Manus Island. Here the fortunate ones, through money, or influence, or luck, might obtain visas and enter Australia, and from Australia to a new life. But the others wait at Manus Island, and wait, and wait, and wait.
No free man shall be seized or injured in any way except by the lawful judgment of his peers or by the law of the land.
This is the writ of habeas corpus. Habeas corpus is used to bring a detainee before a court of law to determine if that person's detention is lawful. This originates in the Magna Carta, a document that was forced upon King John in 1215 by English landowners at Runnymede. It also encompasses a right to equality before the law, to due process under the law, the right not to be arbitrarily deprived of property, and the right to trial by jury. The modern-day use of the writ is to order the release of a detained person, if there is no legal foundation for that detention. What this means is that so long as there is a law that authorises detention, no release can be granted. This has been a large hurdle in many countries when trying to get people released. Today, the Magna Carta is thought of as a foundational legal document that is recognised by many countries as the origin of legal safeguards to fundamental civil liberties. In recent years, immigration detention has become controversial, particularly in relation to asylum seekers and refugees. It seems at odds with the spirit of the Magna Carta, especially the principle to be free of arbitrary detention. Let's now see how countries around the world are attempting to address this issue. Pradeep is a 15-year-old boy trying to escape civil war in his home country of Sri Lanka, with his parents and younger sister Daya. They have spent many weeks and all their money trying to come to Australia to start a better life. Because Pradeep's family have entered Australia without a visa, they must be kept in detention until they are granted refugee status, are sent back to Sri Lanka, or are removed to another country. Though an application may be made for habeas corpus to the Federal Court of Australia, decisions in previous cases have made it clear that a person can be indefinitely detained under Australia's Migration Act. The writ will fail because the Migration Act is a valid law under the Constitution. Unfortunately, for Pradeep and his family, they will have to remain in detention on Manus Island until a determination is made about their refugee status. However, if they tried to enter New Zealand, the law is slightly different. In New Zealand, if 31 or more unauthorised arrivals enter at the same time, an immigration officer may apply to a district court judge to have the group detained for up to 6 months at a time so that they can be processed. If more than 6 months will be required, another warrant must be issued. Theoretically though, the group could be detained indefinitely. However, New Zealand immigration laws add an extra level of scrutiny that Australia's do not. Like New Zealand, the UK has certain measures to prevent indefinite detention. Arthur is a 25-year-old, claiming to be a national from Congo, who has entered the United Kingdom illegally. He has not yet obtained a visa. Since his arrival, Arthur has started a family and has integrated himself into the British community. 5 years after his arrival, he is detained, pending deportation. This is while attempts are made to determine his nationality. During this period, Arthur is separated from his family and his child. UK courts have indicated that a person can be detained for as long as reasonably necessary to effect their deportation. However, once it is established that there is no reasonable prospect of deportation, the courts have said that a person must be released under a writ of habeas corpus. He is released after 2 years, as his nationality could not be determined. Across the Atlantic, the United States struggles to cope with an influx of South Americans seeking a better life. Pedro is a 14-year-old Mexican child who is crossing over the United States border into the state of Arizona, where he has been picked up by US immigration officers. Pedro has travelled unaccompanied. He is taken into custody after convincing officials that he is afraid of being persecuted if sent back. Pedro is detained for 6 weeks before he undergoes a credible fear interview by an immigration officer. This is despite the law indicating that a decision should be reached within 72 hours. His case remains unresolved 18 months later. Government funding is inadequate to cope with such large numbers of immigrants. State-funded lawyers for these unaccompanied children are also limited. Pedro's immigration status is ultimately decided without a lawyer present to represent him. He's returned back to poverty in Mexico. Meanwhile, America's northern neighbour has taken a distinctly different approach. Habeas corpus is included under Section 10 of the Canadian Charter of Rights and Freedoms. However, the Canadian Parliament can exclude the operation of any part of the Charter. They have chosen to do so under their immigration laws. Fatima, a 16-year-old girl, and her father Dinesh are another family trying to escape the Sri Lankan Civil War. Unlike Pradeep's family, they are trying to make their way into Canada. A few weeks after they arrive, Fatima's father is arrested because the Canadian government has signed a security certificate against him. Dinesh believes it may be because of his loose connections to the Tamil Tigers back home in Sri Lanka, which the Canadian government have deemed a terrorist organisation. He's only provided with limited information about why this certificate has been issued against him and is told that he will be removed from Canada. Dinesh fears for how his daughter will cope without him and wants to be reunited with her. He must remain in detention, and his case can only be reviewed once every 6 months. 2015 marks the 800th anniversary of the Magna Carta. We've now seen how different countries treat people in detention. Are we doing justice to the spirit of the Magna Carta? What do you think can be done differently to uphold the principles this important document sought to protect?